case, and not having to be repaid as a condition of probation as a practical matter is going to mean that the criminal benefits from the crime.
Mr. Noonan, isn't the problem with the statute which speaks expressly of victims?
Except that, yes, it is, Your Honor. But what is a victim? I mean, that is what the issue that's before this court. What is a victim? It's not like the legislature said, we say that a victim is a person who owns the property.
You say someone who suffers a financial loss as a result of the crime is a victim under the statute.
I'm saying that in this case, that is certainly the fact. This case is a little closer than the insurance company I referred to, though, for a very important reason. The reason why the $9,200 loss was suffered by Burns International Security in this case was because of their direct employment relationship with this defendant. They hired her to protect the property that she went out and intentionally did the damage to. And they are in the position of the surety of the honesty that's referred to in, I believe it's the Lynch case, the federal case, of their employee. And if their employee deviates, they pay off the owner of the property, and the fact of that payment should not deprive them of the recourse through the probationary criminal process by getting paid back that $9,200. Now, in this case, perhaps $9,200 would justify, the appellate division concedes that a civil lawsuit is not precluded by the fact that probation doesn't permit this order. And in this case, perhaps the $9,200 is a significant enough sum that the order, that the employer may seek a judgment in a civil court. But the large majority of cases that are impacted by the restitution statute, in my limited experience, involve much smaller dollar amounts, $250 or $500 or $700. And as a practical matter, if that sum of money is in dispute, nobody's going to litigate in a civil court over that amount of money. Furthermore, it's been recognized in a number of cases in the lower courts here and in the United States Supreme Court case, Kelly versus Robinson, which was decided in November, and I forwarded subsequent to my filing of the brief, that the restitution process is not really a civil penalty. It's not a judgment, civil judgment in favor of one party against another. It's part of the overall rehabilitative process which is contemplated by probation. That is, in order to make the person lead a law-abiding life, as they say in Kelly versus Robinson, we make as an additional condition that they make this payment, just as we have a condition that they refrain from associating with improper people. And yes, the money does go directly to the victim, but the victim has no control over that order. It's the court that orders it after hearing many things, including the ability of the defendant to repay, and then makes an order consistent with the financial, the means of the person to make the payment. So,
you adopt Judge Wackler's definition of victim as someone who has sustained financial loss as a result of a crime?
Well,
it has to be interpreted that way?
I think, yes. There are a number of cases, including...
Actually, that was Judge Kaye's observation in another context.
There are a number of cases that go way off the beaten path and make orders, you'll give $5,000 to the fire department, or you'll do something like that. And I don't submit to this court, I guess, nor do I have to on the facts before it in this case, that the trial judge has the opportunity to order that you'll make a payment to a charitable organization. But in this case, in the specific case that's before the court, we have somebody who did $9,200 in damage and then was ordered by the court to pay that $9,200 back to the person who suffered the damage, indirectly granted, but because of the employment relationship with the defendant. And to say, for this court to affirm the appellate division, there, to my way of thinking, for a number of possible reasons, which I cited in my brief, the discharge in bankruptcy, which may have changed a little bit by Kelly versus Robinson, but this court's never decided that, I don't think, or the amount of money involved, or the statute of limitations, or a lot of other things, that this defendant has done $9,200 in damage that will not have to be repaid. And I submit that as a policy consideration, this court should say, yes, this party, Burns International Security, suffered a direct financial loss as a result, a direct result of the criminal activity of the person they hired to be in that plan. And therefore, an order by the trial judge after a hearing that amount of money should be repaid by the defendant is consistent with the rehabilitative process and the overall sentencing structure of probation.
Was there any legal?
Now, you use the word direct, and so you would exclude some sort of an indirect consequential loss. You can think of many instances where if you adopt this definition, you could have arguments made that there was a consequence of the loss.
That's
and
true.
that person should be.
Yes, Your Honor. It can be extended far beyond what the court has to do in this
You
particular
limit
case.
it to this particular
Well,
case, and you limit it to a direct,
As a-
tangible loss.
As a matter of pure logic, I would say that the principle I'm espousing to the court at this time would equally apply to a hazard insurance carrier that insured the building, paid off, it's insured. However, I don't say that this court couldn't distinguish between those two, because the hazard insurer, of course, has a whole bunch of risks built into its plan and all sorts of other things. Furthermore, it has no direct relationship with the defendant herself in this case. Here we have
Well, is that the criteria, or is it the obligation on the part of the third party, illegal or otherwise, to make the payment that would be the basis for ordering restitution to him?
Oh, absolutely. I think the legal obligation has to be there. If mom pays it off.
Was there such a legal obligation here?
Was there a legal obligation?
Legal
here?
obligation.
Yes, I submit that there is. That this employer is lawfully obligated to, if you assume in the criminal adjudication process that we have the intentional act causing the fire, which I think we do, we got a confession and there's a plea of guilty or whatever, then
The employer is liable for the intentional criminal act of the employee?
in the scope of the duties, in this case, I think it is, yes.
Arson is within the scope of the duties of a security person?
Well, if you read the statement which I had put into the
But
appendix,
don't you see that you invite all kinds of ancillary problems and questions when you use restitution in this manner?
well, at the very least, Your Honor,
Properly should be
Okay.
ferreted out in a civil action.
at the very least, Your Honor, I think this gap could be bridged by the proof of a contractual obligation or something like that. I agree that is not litigated before the court, but as a legal principle, I think the legal obligation is there.
Thank you very much.
Thank you.
Mr. Zimmerman, aren't we getting very precious when we start analyzing this? Each case has to be decided independently. When we look at the statute, we look at this occurrence, we look at this crime and at the victim of this crime, couldn't we conclude that in this case, certainly, the employer was contemplated as a victim under the statute?
No, Your Honor, I don't believe so. And the reason, well, there's a number of reasons, but I think the primary one is we're talking about a criminal court imposing a criminal punishment for a conviction. And this court has regularly stated certain standards of interpretation of penal statutes that are directly applicable, in this case, to interpreting 6027 and 6510-2G. For example, in the case that I supplemented my brief with, I sent it in, the People v. Green in 68 New York 2nd, just recently decided. The concept that I submit is directly pertinent to interpreting these statutes in this case or any case is defined. Now, you get into a question of the legislative intent, but there's nothing in 6027 or 6510 which indicate anything other than restitution to the victim. And if you look at the White case, which the district attorney put in his brief, and which is certainly pertinent, to define restitution and reparation, aside from legal concepts, go to Webster's, as this court did in the Gottlieb case, which I mentioned in my brief. And clearly, from that perspective, it's limited to the immediate victim. Clearly, the principles of interpretation that this court's defined, and I cited Wood and Gottlieb and other cases in the brief, and Quinlan and Green all talk about the fact that the essential nature of a right to be sentenced is one to be sentenced as provided by law. And if there is a plausible interpretation, if there are several plausible interpretations of these two statutes that are involved here, then the defendant is entitled, under the rule of lenity, to the more favorable. I don't believe that there's anything in the law that supports a broader definition of victim than that it's the person immediately impacted, Trojan. As a matter of fact, it came to my attention that the legislature just passed a new article of the CPL 21520 where they do define victim. I mentioned a number of statutes in my brief that are just relevant in terms of dealing with the term victim. But 21520 defines victim. That's where they now permit ACDs of felony cases in certain limited instances for referral to community rehab centers or whatever. And there's the most recent definition. The definition, use of the terms restitution and reparation by definition are limited to the immediate person.
Does it use that word, Mr. Zoon, to the immediate person? Does it use
The statute?
that? Yes.
No, sir. No, it does not.
So that's your interpretation of what that definition of
Well,
victim
that's
means.
White's that's the case law interpretation, and that is, what I'm saying is that the new section of the CPL that I referred to does use the term victim and defines it as the person directly impacted, yes.
And you also referred us to Webster's dictionary.
Well,
I know that the Chief Judge is very often reminding people that Webster's usually looks to what the court says as a definition. So if the court were to interpret it differently, we may find a different interpretation.
Well, that's why I bring Webster, because it was used by this court in the Gottlieb case in resolving the definition, and so I bring it again because because White used it in the appellate division in another case in the same context. Certainly, you transcend Webster, but it's there.
I only say that because you're here today.
Well, I say it because I'm realistic enough to recognize it. I would just looking at the two statutes involved, which is, this court has looked at them, of course, previously in a different context in the Fuller case, but even in the Fuller case, you recognize in the fact of the essential nature of the right to be sentenced in accordance with law. And here, restitution and reparation under the law, the penal law sections, is clearly under the statutory norms of interpretation defined by this court, and under the case law that has been presented in the brief and supplemented by your most recent decision, I submit that that is the law of this state. And the final point I just make, because federal law was mentioned.
In other words, had the court, though, said that reparations or restitution was to be made to the victim, that would be fine, right?
To the victim, yes.
Yeah.
Yes, Your Honor.
So therefore, if we do that, send it back and say for the court to do that, well, that would be satisfactory.
Well, there's a record in this case. We had a hearing under 41020, and the record indicates they produced the chief executive officer of the victim who said, we're not looking for anything, in effect. That's in the record. Just one final thing, though, because federal law is mentioned by the Fourth Department in this case, and it's been mentioned in the course of argument. It's true that because of the similarity of language, aggrieved party used to be in our penal law, it's still in the federal probationary statute. My position is, with regard to the policy reasons stated by Mr. Noonan, or any policy reasons that would occur to you, he's in the same posture as the dissenter in Feldman versus Reeves. The dissenter said, equity requires that these funds be paid to the larceny, that they not be returned to the convicted criminal. And the answer was, go to the legislature. That's a great argument. But you can only punish people under statutes. We can't, I would submit that these statutes do not permit what occurred to my client in this case. Thank you.
Thank you very much, Mr. Zimmerman. Matter of Continental Bank International versus City of New York Department of Finance.
May it please the court, the question in this case is whether the city can lawfully tax a petitioner's entire net income from business done within the city.
If this were a regular bank, because of the repeal of the exemption from taxation, there's no question but that the city would have the right to tax.
If this
And
were
that's
a
so.
national bank, Your Honor, that is correct.
But because of this, it's an edge bank, so-called, you say it can't be.
That is correct. We say it cannot for two reasons. One is Section 627 of the EDGE Act, and the second is quite apart from any statute, the Constitution. Now, I want to address first the statutory question. Section 627 provides that the states can tax EDGE Bank's shares as part of the personal property of the shareholders, but that the EDGE Bank itself shall be subject to tax by the state within which its home office is located. Now, our position is that Section 627 provides the exclusive rule governing state taxation of EDGE banks and their shares, so that an EDGE bank itself is taxable by its home office state, but nowhere else. Now, this statute was written in 1919, at a time when there was nothing at all unusual about a federal statute limiting the state and local taxes that federal banks would have to pay. In fact, at that time, every federal bank, without exception, was exempt by statute from most state and federal taxes.
And at that time also, Mr. Keene, there were no branch banks, isn't that so?
That is approximately 95%. So there
Well,
were...
there were agencies, but they were, by taxing the home office, the home state could reach the agencies which were controlled by the home office.
Does the question go to banks generally or to EDGE banks?
Only to EDGE banks.
Starting with the first version of Reg K in March of 1920, agencies were permitted, and have always been permitted. Branches were prohibited until 1979. But the point is that satellite offices were permitted throughout the country.
Is there any difference except in the legal structure between an agency and a branch bank?
The terms are not defined in this statute, and the legislative history indicates some confusion as to the difference between the two, or even whether there was any difference between the two. Now, you can look to other statutes and get other definitions, but I suggest that they're not terribly relevant here. Presumably, an agency has somewhat more limited powers than does a branch. But still, an agency is one way of setting up an office, going into a state, and conducting your business.
My question was, though, at the time of the enactment, by permitting tax at the situs of the home office, the legislature was in fact permitting the state to tax EDGE banks.
Precisely. The home office was permitted to tax.
And there were no branches at the time.
There were no branches, that's correct.
There was only a home office. Therefore, the legislature was permitting tax of the bank itself in the only way that it could.
No, I don't think that's correct because of the agencies that were allowed. And as a matter of fact, the statute itself does not prohibit branches. This is a function of the Federal Reserve Board. The Fed, in its wisdom, in its early pronouncements, decided that branches would not be had, but that agencies would be.
Well, there's at least this much distinction. In this case, the Congress made a declaration that EDGE banks would be taxable at some place, and in some cases they said banks will not be taxable. Isn't that so?
In this case, they said that EDGE banks shall be taxable in the home office state, period. They stopped there. Yeah. That's true.
But they made a policy decision that we're going to tax EDGE banks to some degree, whereas other banks were not taxed.
That is not quite correct, Your Honor. And going back to 1919, and I'm talking about then and not some later time, every federal bank, including EDGE banks, were tax exempt up to a point and were taxable beyond that point. The point varied somewhat. National banks, for example, in 1919 were subject to real estate taxes, but to no other taxes. The same for the Federal Reserve banks, the same for the federal land banks. There was no federal bank of any sort in 1919 that was subject to unrestricted state or local taxation. This was an established federal policy, and I submit to this court there is no evidence in the EDGE Act or in its legislative history that Congress intended to change this policy in the case of EDGE banks. Quite the contrary. The legislative history is full of references to the taxation of other kinds of banks, with a clear indication that Congress intended that EDGE banks would be pretty much treated the same as the others. That is, they'd be taxed, but only on a limited basis. And the limitation was they're taxed here at the home office and not elsewhere where they may be
Where
doing
do we
business.
find an intention to limit the tax?
In the words of the statute.
Nowhere else.
Yes, I think the legislative history shows this. I think that's so.
Is there an expression in the legislative history that we intend to permit this tax only of the home office and not of any other facet?
I do
of
not.
those banks?
I do not find those words in the legislative history.
So then it
that's
could be
correct.
said that those are not words of limitation then, but
No, I
an
don't think-
authorization as to one particular kind of tax.
Not at all. No, I think the whole purport of the discussion on the floor of Congress, and most of the legislative history is from the congressional records, the debates on the floor. We do not have authoritative committee reports that spell this thing out, so that we're at some disadvantage there. But the whole purport here was to find out what was the tax situation for national banks, for the Federal Reserve banks, and so forth, and let's write something like that for the EDGE banks.